Where were we at the last thing?
36B1, my lord.
36B1, yes, madam.
Arresting authority signing as a witness under 36B1.
You have to show us that. I think they were arrested. There were two persons authorized
Yes.
and one of them arrested, the others,
Under
other was the
36B1.
witness. Yes.
One, and second, my lord, violation of section 48.
Two issues and we can close this. Please.
I will give their answer
Hmm.
precisely what they said. The person who has put the signature there, he was accompanying the arresting authority. During the relevant time, there was no net and there was a curfew also because
Huh?
of the curfew law, because of the law and order situation. Total area is Band call is there. And from one militant organization, they have also called for the Band and there was burning, rioting and everything to that effect. I have written to my department, they have clarified the issue. This is
So he was arrested amongst the burning and curfew.
because no one could go outside, nobody was there. However, he was arrested there while he was there in the airport.
Airport. So in the
Airport.
airport, there were no police officers, other independent police officers.
Yes, Your Honor. To that effect, I am giving. Looking to his
Presence. Let us call it the presence.
presence, or I don't want to use any
Aura.
other word, or
Yes.
his,
Huh?
nobody is there to come and sign there. Nobody is there to come and sign.
From where do we
That's-
find that?
And TIP is also there. This is a.
No, that part. From where is he stating all these things?
This I am situation I am showing. This is the press release for that day, 678, and this is the notification which will reveal everything with regard to the law and order situation during the relevant
We
period.
understand everything. That since no one else was present and this person was required to sign. From that document of that day, where do we find it? We will definitely consider this aspect. We are not brushing it aside. We will take this into consideration.
Through HOB plus IO, both the letters are there in the last page I have attached because I have made these queries, and these are the press release given by the head of the branch. CBI arrested Mitai outfit, Arambai Tangle, and because of his arrest, all looting and arson started at that point of time. It is given.
When this man was arrested.
Was arrested on.
No, this because of the arrest of this man, everything started.
Prior to that, it was there. Ethnic
Violence,
it
was there.
It was there, and this constable was already terminated because of his all illegal activities from their department. Thereafter, he was being, during the course of investigation, since investigating agency could not able to arrest him, the investigating agency were search of him. And ultimately, he was found over there in the airport. And looking to the situation, they cannot go outside the airport. He has to produce here in the magistrate court in the Guwahati. He has been immediately brought to the Guwahati instead of making any delay and looking to the situation, because their own people, they have come to know that this person is arrested and they started all arsoning there. This is detail given in the press report, if your lordship will permit me.
My lord, I also
For the
very
sake
important
of
copy.
state, for the sake of sovereignty, I want to read it.
Copy, my lord. What?
No, this is the press release.
I have to go through my.
This is already there on the, and this notification is also there. If your lordship will permit me to read it meticulously, then lordship will appreciate the fact, because
First
it
page is
the innocent people and
the first page is regarding the banning of the internet connection. Yes.
and thereafter why it is banned.
When was he
It is
arrested?
there.
The date?
8/6/2025.
And this
8th
is
of-
7th June.
8/6, huh?
7 June.
Hmm.
And the ethnic violence was occurred in the 23. Since then, he was being our investigating authority is searching him. And ultimately, right from 23, he was arrested on 7th June 25. It was so difficult to arrest him. 8th June. He was in the surveillance, but it was difficult to arrest him. And ultimately, he was arrested on 7th June. Since 23, he is evading the arrest. I'm going through, Your Lordship. In view of the prevailing law and order situation in the state of Manipur, especially in Imphal West, East Thombal, Kokokching, and Bishnupur district of Manipur, there is an apprehension that some antisocial element might use social media extensively for transmission of image, hate speech, hate video message, inciting the passion of the public, which might have serious repercussion for the law and order situation in the state of Manipur. And whereas there is an
No, that we have read, that it was, that
now I'm
internet
coming to
ban
the
was
press
imposed.
release. Press release. This is a authentic given to me from the CBI. I will start from the half of the page. The CBI statement made it clear that the Singh was arrested from the Imphal airport on Sunday. As a preventive measure, the administration has issued a prohibitory order in the Imphal West, Imphal East, Thombal, Bishnupur, and Kakching district, while internet and mobile data service, including the VSAT and VPN facility, have been suspended in this
When was he produced at Guwahati?
on the very day. On bringing.
Sorry,
I will,
sorry,
that,
ma'am.
that will be Sunday. He was arrested on Sunday. He was produced, you definitely either on.
Definitely no, but there must be something. We will not have a
CD
definite.
will speak that. CD said.
We are trying to now conclude up the thing before,
Chief
in the
Judicial
next.
Magistrate Kamrup Metro, my lord.
When
On 8/6/2025.
he was,
4:30
just
PM.
a minute, on 7/6,
8-6.
on 7/6/2025, there is an internet ban and everything. है ना?
Yes.
Internet ban is there. Then on 8/6/2025, what time was he arrested?
My lord, 9:20 AM
9:20 AM. This is a Sunday, right?
at Imphal Airport.
This is Sunday.
Sunday.
Sunday, my lord?
Yes, Sunday.
Imphal
Saturday is 7-6. I have.
Sunday,
written
my lord,
Sunday.
Airport. We are not deciding anything. We are just trying to
I'm
take
just
down
trying to
the
give the figures as asked by your lordship, my lord.
Imphal Airport, at Imphal Airport arrested. है ना?
PM.
Then when was he produced?
4:30 PM, my lord.
At
At Chief Judicial Magistrate Kamrup Metro.
Kamrup
Metro.
Metro. Okay.
And time is
On the
specific-
same day,
Same day, my lord.
8/6/2025.
8/6/2025.
Okay.
They brought him by flight.
Then from then on, he is behind the bars.
Yes.
है ना? Behind the bars. Now we will just try to note down. Petitioner, you have made two allegations. 30 section notice under.
36B1,
Sorry, 36
B1,
B1.
and 48.
Uh,
Lordship.
yes,
36,
yes.
B1 and 48. Now, my lord,
Sorry, signature by
the
by
arresting
one of the IO.
IO
IO/person arrested, a
Authorized to
person
arrest.
authorized
to arrest.
to arrest. He is,
The
unless he has
person who
given,
is accompanying the IO.
These are wrong submissions, my lord.
but I do not want
I-
immediate reply. Yesterday
not
also I said this is not kaun banega crorepati, fastest finger first.
My
Nahi
lord.
chalta hai. You had that piece of, you had given us that piece of paper. We'll confront her with that.
48.
We'll confront her with that as and when necessary.
My lord, my lord.
এইটো হেৰি কৰকচোন, এইখন ভিতৰত দিব হা। Who signed it, madam? The witness is Manish Kumar.
Please.
Is the witness Manish Kumar or Rajesh Meena?
Rajesh Meena,
Rajesh Meena is the witness.
witness. As a
Now, your authorization, in view of the above, since the undersigned is camping
Manish
in,
Kumar was the sub-inspector. He,
in view of the above, since the undersigned is camping in Kolkata, I hereby authorize Rajesh Meena Sub-Inspector and Manish Kumar Sub-Inspector, both posted at CBI ACB Guwahati, to locate the present whereabout of Kanan Singh and arrest him. So Rajesh and Manish were both
Authorized
authorized to
this investigation
and
as well as
arrest.
arrest also.
Yes. So the submission of the petitioner that this the one of the witness was, or the witness was also authorized to arrest him is correct. Whether he could have done so or not is another issue that we will adjudicate. But the factually it remains that he had.
Proves that even if the person is not
True,
authorized,
we'll-
then if some.
It is for adjudication. We are on the fact part of it.
We can arrest.
We are on the fact part of it. We are only on his submission. Whether he was authorized or not is the only submission he is making that we have to take into consideration. So, yours is 36B1 signed by a person who was authorized to arrest, and the second is 40.
And he 48, my lord.
Hmm.
But on 36B1, my also submission also there that he is neither a member of family nor a respectable person. Independent. Respectable.
Independence is not there. Independence
witness
of
is written
the
here.
independence of the huh?
Name and address of the independent witness
Who?
within 17, clause number 17.
Hmm.
And within bracket, whether friends, relative or member of the family.
Hmm.
It definitely is not the friend, relative or member of the family. As an independent witness, he has given the signature.
Okay. Your submission is that if 36B1 is not followed and there is no respectable person who signed it
Family member, respectable person.
or family member, but we are keeping that apart because no one was there at that point of time. It should have been any other
Respectable person.
independent, respectable member is your submission. And your second submission is
And-
that 48 notice, someone should have, there should be some indication that it was provided to some family member in some manner where they came to know about the ground of arrest.
My lord, may I
Hmm.
add up, my lord?
Hmm.
36
Hmm.
Q1, there was a query from the court that
Hmm.
what is the effect of violation of
Hmm.
36B1.
Hmm.
Then lordship, I passed that Kolkata High Court bail order,
Hmm.
my lord. I have a proper answer, my lord. From judgment shall show, it is very specifically written that if 36B1 is violated, then it is violation of Article 21 and 22. I have the judgments. As Guwahati High Court judgment, I will show.
Now,
Bombay High Court judgment, I
There
will
will be
show.
also one thing that this court is going to consider while delivering the judgment is the prevalent circumstances in which everything happened.
That also I'll reply.
The denial of this court cannot shut the eyes that at that point of time, whatever was happening in Manipur, Imphal, other places, was something which was extraordinary as of today's society. In that circumstances, the violation, if any, the preceding part and the immediately succeeding actions taken, would that play any role?
My lord, for that I'll place the judgments as I have said. That violation of Article 21 and 22. Clear violation if 36B1 is not followed.
Yes, we
And-
totally agree.
And we have to go as per the provisions provided under 36B1. Who can
Yes.
sign? Nobody other than that. And on that day, my lord, the entire plane, my lord, aeroplane, full of passengers. Airport was busy. Customs people were there at airport. So many officials were there at airport. And airport, my lord, entire airport was open. I have just inquired. It was functioning. There was no bar from getting one independent person. But the thing is that, my lord, I asked my client, he signed it at Guwahati. And actual fact, my lord, I have the video and everything we have, but we cannot show to this court. He was picked up and we have made averment in our bail petition. On 7th evening, he was picked up from a petrol pump. Entire evening, he was kept. Morning, he was brought to Guwahati on 8th. What is coming out from her mouth, submission on 7th, arrested on 7/7, that is correct. That is our averment also in the bail petition. For a moment. That is our averment also. 7th evening picked up,
No.
kept in a secret location. Morning brought to Guwahati, early morning, everything signed at Guwahati. That is the reason why they could not serve this 48, 47 odd. And my lord, On 36B1, my lord, with judgments and all, I'll make submissions, my lord. Violation, everything I will show, my lord. One more disturbing thing, my lord. When I come to 48, my lord, two things. First, they are saying that they have served it through WhatsApp. I will show Supreme Court latest directions. WhatsApp service is not allowed in cases where it is not allowed. WhatsApp service is not allowed when it has immediate bearing on my liberty. Also, Supreme Court says when the violation of some sections or notice under some sections has got immediate bearing upon my liberty, then it cannot be WhatsApp. One. Second, any notice under chapter 5, like 47, 48, all this has to be as per chapter 6. Why I am saying so, my lord? More disturbing fact have come up in our research yesterday. The 48th notice they have sent by WhatsApp, sent to a minor, 14 years old girl, Lisa, the daughter. They have made statement that notice was served to Lisa. 48 complied. How? Because WhatsApp given to Lisa. Lisa's birth certificate will produce. We'll give them a copy also if they want to verify. She is 14 years, my lord. Service to a minor is no service. And anything which we have to serve to a minor has to be served to a legal guardian. And my lord, in support of that, my lord, I will make my argument, my lord, from section 66 of BNSS under chapter 6, which says that any service of notice has to be on adult male member. I will argue on section 153, 1 small a of Customs Act 1962. It says service has to be on adult member. Even CPC, my lord, this is a criminal case, I understand. CPC Order 5 Rule 15 says it has to be an adult male member. Now, my lord, this cannot be allowed. So, my lord, here 36B1s, they have made a complete mockery when the arresting authority signs. 48 also, my lord, how can a minor be allowed? What she knows? Even if admitting for this sake of argument that is served it by WhatsApp, even if saying that it is allowed, minor, that cannot be, my lord. 14 years minor cannot be. Tomorrow they will serve it to 8 years minor. Minor cannot be. And for that, my lord, precedent has to be set, my lord. On these 2 points, my lord, these two are gray areas, my lord. One, this arresting authority signing, and second, notice 48 notice is served to the minor, my lord. These two are gray areas in this case. And with regard to 48, when I am saying that all service or under section 48 should be as per chapter 6, this is also a half-baked, because what judgments I will place is with regard to 35. Coupled with the fact that Supreme Court says that if it is a question on my liberty, then chapter 6 has to be followed. So, since for 47, 48, all this come under same chapter. So, this also has to be, 48 also has to be as per chapter 6. If Lordship allow me, I will take your Lordship through one by one, my lord.
But we will not go through the entire this thing.
No
Just
facts,
point out-
my lord, only
just
law.
go through the relevant portion of
My
it.
lord, I am just making a submission. My lord, if Lordship is convinced on 36B1 and 48, I wanted to argue on 47 also. I also wanted to argue that there is no chance of conviction. All this I am keeping reserved, my lord. I will not argue. Today I'll argue only on 36B1 and 48. If Lordship is satisfied, then we'll not go into all this, my lord.
Yes, we can
Yes.
say that.
Yeah. Guwahati High Court to dia. মোক হেৰিটো দিয়াচোন, এইটো প্ৰিণ্টিংটো দিয়া না আমাক। গুৱাহাটী হাইকোৰ্ট দিয়া আৰু দিয়াচোন। Lordship may kindly, this is our High Court judgment. But it is 41B আছে নেই? There are 29 and 30, my lord.
Era?
29 and 30. May I read, my lord? As far as the submission that there is a violation of section 41B, B1 of CRPC in arresting the accused applicant is concerned, this court has perused the arrest memo given to the accused applicant while she was being arrested, it is found that there is no attesting signature of any member of the family of the accused applicant or of any respectable member of the locality where the arrest was made, directly matching with our facts. Para 30, in the case of DK Basu versus State of West Bengal, it has been clearly provided that it is desirable that the officer arresting the person should prepare a memo of arrest at the time of arrest in the presence of at least one witness who may be a member of family of the arrestee or a respectable person of the locality where the arrest is made. Therefore, it is seen that the mandates of the principle provided in the case of DK Basu, which has flown from Article 21 and 22(1) 22(1) of the Constitution of India, is to be strictly followed. However, in the instant case, apparently the provisions under Section 41(b)(1) have been completely violated, thereby depriving the accused applicant of her fundamental rights guaranteed under Article 21 and 22(1) of the Constitution of India. So this was the query from the court. Answer is this, my lord. Effect. This is the proper answer. Now, Bombay High Court, I will place, my lord. View taken by Bombay High Court. Para 12. Paragraph 12, my lord. I read, my lord.
Hmm.
12. This court is considering the present matter only to consider the act of the respondents of illegal detention of two petitioners. The provisions of Article 21 and 22(1) of Constitution of India show the fundamental rights of the persons like petitioners. The safeguards needs to be provided for compliance of Article 21 and 22 of Constitution of India against the arbitrary arrest and detention. It needs to be presumed that aforesaid amended provisions of CRPC like Section 436, 41A, and 41B are to comply the mandate of Article 21 and 22 of the Constitution. Section 4. So, my lord, this Bombay High Court also says this fundamental right. And my lord, yes, on the last occasion we have placed one judgment from Kolkata High Court where due to violation bail was granted. Now, lordship, we have another 7 judgments. There are numerous. Kolkata High Court, my lord, is taking, if there is violation of this section, directly bail, my lord. On one ground. On this whole ground of 36(b)(1), bail has been granted. If required, lordship, we can just place the judgments and not read.
Take- Give us a
Place
list.
the bunch. This is the bunch, my lord, I am just providing, all on similar, my lord, 36(b)(1) violation. And one judgment on the last occasion I have given.
You will have to resubmit that Kolkata one.
My lord, yes.
This is Kolkata 2023, this one.
There are 6 judgments are there, no? 6 are here, one I have submitted on the last occasion. My lord, we'll make a,
It's, huh?
6 are here, on one
Hmm.
last occasion, 7 bails on only on this sole ground. And why? Because it violates Article 21 and 22. And that is, my lord, I have shown from Guwahati High Court judgment and Bombay High Court observations, my lord. Now, my lord, what point I am keeping, my lord, for adjudication of this court is that my submission, my lord, is directly on the point that I am saying that one person cannot play 2 roles. When there is arrest, there are 2 roles, one arresting authority and one accused, one witness, and in the middle is the accused. This arresting officer, he will come and say, yes, I am the person authorized to arrest you. See, this is the authorization I got from my superior. We are arresting you now. And at the same time, he goes the other side and he says, yes, I'll be your witness as family, member of family, friend, relative. So, my lord, one person cannot play 2 roles. So, my lord, this we keep up before this court, my lord, bring up before this court for adjudication. And my lord, this is a gray area. We have made extensive research. Nowhere we have found that a police officer or any of members from the raiding party signing an arrest memo under 36(b)(1) or older 41(b). No, there is no such case laws we have found. So, lordship, it is my humble prayer that if lordship is satisfied with my reasoning and my submission that this cannot be, because this will violate the fundamental right, then lordship may kindly set the precedent that at least whoever may sign, there is no problem with that, because on last occasion lordship also had put a query that if it is a lonely road, what will happen? Now, my lord, what happens? Police finds a person, or actual fact I will say, my lord. Police finds a person on a lonely road. They don't serve arrest memo there, my lord. They take your arrest memo, come with us. No, they will pick him up, take to the police station, and then interrogate. After interrogation, if police deems it fit that he needs to be arrested, then arrest memo is given. Now, my lord, the law is a police can pick up a person for interrogation. Now, in this case, if we come and say that we were picked up in the evening of 7/6 and we were produced before the magistrate only or at 4:30 of 8/6, after 24 hours, we cannot take that ground. Because if today we take that ground, then CBI will say, no, 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 we just picked you up for interrogation. We interrogated you entire night. And then we thought at 9:30, at 9:20 AM, we thought that your arrest is necessary. So we arrested you at 9:20 and then we produced you before the magistrate within 24 hours.
That has been set aside by the court.
Fine.
The court has already set that ground aside. The moment there is an admission that we have picked you up at so and so hours, 24 starts then,
Is there, my lord.
starts from detention.
Now, my lord, when police went there, my lord, entire team was there. It could have been anyone, any Havildar also, my lord. If the PSO of the IO also, then he could have signed. We could have said that yes, he's independent. One person who has his name on the authority letter can never be independent. So, my lord, we want this precedent also to be set if Lordship is satisfied with our reasoning and argument that let anybody sign, but one person may not play two roles. One, he will be a person authorized to arrest, and another, he will be a witness. Dual role may kindly not be allowed. That precedent we are praying to be set down, my lord. And this is a gray area.
Why do we need that witness to the arrest?
My lord,
Why do we need a witness to be to the arrest?
why do we need a witness?
Why does the law require there to be a witness to the arrest?
Witness to the arrest. Otherwise, that's why, my lord, habeas corpus
Because
petition is coming.
if we say that it is for the purposes of informing the family, informing the relative, informing the friend, informing whosoever it is, that is already played, that role is played by the notice under 48. So a witness at the time of the arrest has to have some importance.
The importance is that, my lord, I have not brought the judgments, but while doing the
Otherwise-
research, I have come down, I have come across this. The reasonings by the Supreme Court, my lord, or in some courts I have found, it is that if a person is dislocated from a place, there has to be a person who says that yes, he is taken by
It
the
was done
police.
with the authority of
Yes,
law.
police took him. So one person has to stay back there
Mm.
to inform the family members. Otherwise, police will go. They will pick up anybody and then family will come with habeas corpus petition. That is the reason, my lord,
Mm.
that one independent person or family member or someone may be present. Otherwise, court has judgment to ase niki? DK Basu, I am reading, my lord, para 34. In addition to the statutory and constitutional requirement to which we have made a reference, we are of the view that it would be useful and effective to structure appropriate machinery for contemporaneous
Sort of introduced that paragraph sort of introduced the provisions of 36(1) that someone
Yes.
should be a witness to the arrest.
to bring transparency and accountability. These two words have been used. That's why, and my lord, this is a mandatory provision. And if it is not followed, then it is violation of fundamental rights. And where there is a violation of fundamental rights, arrest becomes illegal. And if arrest is illegal, my lord, accused is entitled to bail. And my lord, they have now, lordship, may I come to 48 now? 36, this much only, my lord. I have shown for 36, I have shown, my lord, how non-compliance is violation of fundamental right, I have shown.
48, all arguments of the CBI being taken, being accepted for the sake of it. Even then, service of notice on a minor will not suffice.
Will not suffice, my lord. And for that, my lord, what I have prepared is that I have prepared that any notice under chapter 5 has to be under chapter 6. I'll make that argument. And my lord, I will give Delhi High Court, my lord, judgment is there. Then one notification is there, order is there from the Delhi police. And then Supreme Court order is there, my lord, approving all this, my lord. First of all, birth certificate can be placed. Lordship, I am just placing birth certificate before Lordship, and I'll also giving a copy to the CBI, my lord. If they want, they can verify from the authorities. And in case, Lordship, later they find someday that this is fake, they may come and inform the court. This is the birth certificate. She was 14 years, my lord. Lisa.
Okay.
And my lord, Juvenile Justice Care and Protection Act says police officer cannot go before a child with uniform, bats, etc. So much protection is given. And my lord, these police officers, they will inform the minor about arrest of father. What will be the mental condition of the minors if this is allowed, my lord?
She is the daughter or niece.
Daughter. Is the daughter of this.
Where is their statement that this Lisa was informed? Yes,
Yes.
we also remember reading it.
Page 111. Asane re?
There is in fact given by
Constable,
accused himself.
kindly see, my lord, page 111 and also remand order also. Remand order there. Page 111, my lord. At the top, they have made the note. Remand order sahi to diya na.
This we have taken
My
in
lord.
our objection also.
Chief has
You've named the lady, na?
Right.
You have named the receiver.
First, we have tried to contact Y.
Hmm.
When her mobile phone was switched off,
Ah.
then we have accused has given this number and we contacted. And
But-
that person has come yesterday from the HOB and from this page 8 I have already given, which has been written to me for the clarification I have asked for. It is submitted that the accused applicant himself provided the mobile number so and so belonging to his wife, me Boli Devi, to the arresting officer, and accordingly when contacted this number was found switched off. Thereafter the accused applicant provided the number so and so belonging to his friend Chingi Thang Nambam, and accordingly his friend was informed about the arrest of the accused applicant at the time of arrest.
my reply, my lord, would be whatever may be the circumstances, whatever, my lord, under no circumstances, service upon a minor. Whatever may be the circumstances. And
They sending it to a phone number which you had provided. Cannot be taken to be wrong. But when this court comes to has the knowledge that it was served upon a minor, will it suffice 48 is what we will see. We will not take it to be their intent to serve a minor.
yes. I understand.
They were given a number, they serve it. Did they fail in their duty to find out whether the daughter is a major or not?
Yes, my lord. That is my submission, my lord. My lord, if lordship is satisfied on that point, law has to be set down on that point that you verify the person whom we are giving daughter, if she is a daughter, what is the age? And my lord, Liza's name, lordship will find also in the remand order, which I have certified copy already I have given. There also it is written the grounds of arrest has been communicated to the accused person by serving notice under section 47 of the BNSS, and his daughter, namely Liza, has also been informed by serving notice under section 48 of BNSS as mentioned above. So it's Liza, my lord.
This has also been served to the Babita, who is sister of
And-
the accused applicant.
Sorry?
It has also been information has also been given to Babita, sister of accused applicant. We have given in page number 8 today, we have
The
provided.
very manner in which you withdraw the word notice and you introduce the word information,
Yes.
it crumbles the entire confidence this court is trying to build. When the respondents want to substitute the word notice by information, that crumbles the whole confidence. The respondents' assertion, if they had asserted that this information is notice enough, we could not have done more, then the line between a notice and an information thins out.
It's a very
But the moment you say that the notice information was given, that very moment we notice that the notice is not there. That becomes difficult.
entire scenario
Mm.
during the relevant time. As my learned friend said, that even in the flight, we could have taken the signature of any independent witness.
That is
Does
not
it
my-
viable?
No, that is
any
not my
particular
submission.
gift?
That is not my submission.
And another submission, it was full of passengers and airport is full. At that point of time, everything is closed. Bandh was prevailing from last 7 days. None of the person was there. And after 2 years, this person is apprehended. And very much influential person there. Everybody knows his name. Nobody will turn up.
My lord, if arguments are being made on facts, my lord, merits, my lord, I have reserved that argument. My arguments, my lord, I have reserved on the merits. We are only on law point, my lord. That whether followed or not followed, whether needs to be followed or need not be followed. Whether mandatory or not mandatory.
To that effect, I will show your lordship Supreme Court judgment. I have also judgment. Not of the High Court, of course, the Supreme Court, of the division bench.
So,
My lord, now, my lord, I am pressing on the point that notice cannot be served. Notice under section 48 cannot be served to a minor.
Mm.
I am making submission on that point only,
Mm.
my lord. Now, my lord, now suppose today this is taken because I have raised an issue, my lord, now that this notice served to a minor is illegal, non-est in the eye of law. So, since I raised an issue, my lord,
the only thing that troubles us all the time when when we are going through these kind of cases, we are discussing because so that we can have your views on that also.
my lord,
On a number provided or on a person nominated by. No one comes up to make a statement that this is the person I had nominated. And it was not informed to him, but rather they found out that person and informed it to him. Now, the mobile number of the daughter did not come up in the air. There must have been some reference by someone that this is the number. Send it to him, someone in the family gets it. I don't know who it is, but someone in the. From where did that number come?
my lord,
If the number is provided by the father, assuming, allowing the notice to be sent to the daughter, can we accept now when the petitioner comes up to say that this is the minor? My phone number might be in my daughter's name with the Aadhaar card. She might be a minor. She might be using my major's phone number, but it is with my minor daughter.
yes. That's why
So
Supreme
that whether it was sent to the minor, there is no assertion from the petitioner as of now saying that this is not a number I provided. These are the numbers I provided. They were active and the notice did not go there. No attempts have been made to that. Specific affirmance that the number given was of the wife is switched off. What more?
That's why, my lord, Supreme Court, my lord, says.
Mm.
That's why Supreme Court says that this type of notices not allowed through WhatsApp.
True. So so what you would want us to conclude is once that phone number is given, the person is at an unreachable place where the arresting authority cannot go because of whatever conditions. The 48 hours, the 24 hours will pass, the 2 hours before production, before magistrate pass, everything happens. Traveling time is more than that to the place of a place where the person wants the notice to be served. It will take more than 22 hours. Therefore, bringing down the 2 hours will be also violated even if I make a move now. The notice cannot be served during that. What happens?
my lord. There may be, my lord,
I have come through a case where the person is from Chittur. Sitting here, he says, go there. The arresting person, he investigates or he runs around with a notice to Chittur.
no, my lord. In this regard, my lord, there may be many situations, my lord. Let me constrain myself to my facts, my lord.
We are trying to do that only.
I am from Manipur.
Ah,
You have arrested me from Manipur
ah,
airport.
ah.
You are not calling any family member or relative or friend at Manipur. And you came, brought me.
Where is that nomination? Call him. Where is that?
My lord, there is no form for such nomination.
The provision of law which we have been trying to go through says that person nominated. We do not understand what is that nomination. None of the petitioners try to explain us what is a nomination. Today you have asked me a question, where is that form? I don't know where is that form. That is why we are putting that question.
My lord.
If you have 48 for a moment, have 48 for a
my lord, I
moment.
am also taking out
Just have 48 for a moment.
48.
আরে, বাস, ব্যাস, ইখন ক'ত গ'ল? হ্যাঁ? Oh, BLNSS. Thank you. 48.
Should be relative, friend,
Huh.
or such other person
Hmm.
as may be disclosed
Or nominated.
or nominated
Now,
by the.
now I nominate my minor son. I don't tell it's a minor. I nominate him. Message has to be sent. Because someone in, if I'm arrested in Orissa or if I'm arrested in Karnataka, they don't know whom I have at home. May not know. So I'll nominate one. That nomination has to be verbal on the spot. I will not be signing anything. I don't know how to read and write. Fine. They're asking me Hindi. I said Kannada, please. Give me Kannada. I don't know. Everything is in a soup now. I just have to delay it for the next 24 hours. Everything goes.
Yes, I get.
Can that be the intent of the orders of the Honorable Supreme Court? Cannot be. It has to be a situation where we can find out that yes, this is the maximum limit. Or no, this has to be an exception. Somewhere something has to come in. The law that you are placing before us is a law which is going around. Here is a situation where the respondents are trying to say, look at the situation. We cannot move. Their assertion, we cannot move. We are having a person in our hand who is a, if you may use the term, it's hot cake. Anybody will try to take him away from us. It's precious now. We are two persons standing on two sides of him. One will not be enough. We need to complete the formalities. We do it with honesty. We do it with integrity. May not be sufficient according to the law. We do the best we could. We brought him back here. Flight hour, up and down, traveling time, everything taken together. By 2:30, we were at the airport. By 4:30, he's before the magistrate. Before the magistrate, these are the statements made. Because now we have again seen from this thing. Now that is what we will look into in the trial court record also. He gave the phone number before the magistrate. If that be so, man is giving a number. Where else to send it? I'll have to drop him here and I'll have to go back. Can that be the intent of what's, when we talk of Article 20, when we talk of right to life, liberty, whatever, Supreme Court recognizes that there has to be a certain extent that you can go to. You can do it in accordance with law. Is it only with accordance with law? Or does the doctrine of necessity flow in? At times. Will it flow in? Has it to be taken into consideration or no? It has to be Patthar ka lakir. You cannot, it has to go. Then it will be a weapon. It will be a weapon where the trigger is with the person who is violating the law, who is alleged to be violating the law. Need be stretched to that extent. That is a debate whose answer, whose arguments we are not finding anywhere. This is a question which for the last 2-3 weeks I have been trying to put down to everybody. what is this nomination? How do we take that nomination? Whom to believe? Just because a man's liberty is being questioned, are we to question the very integrity of the officers who are certified, who have certified integrity everywhere? Every of the service records will say he's an integrity man with integrity. He is given a job to protect the country, the peace, the quiet of the country, and then we say no. कुछ तो बदमाशी है. Machinery function then. If we go by such strict interpretations, as lawyers, one would do his duty. As a defender, she would do her duty. As a court of law, I would be interpreting. Assisting the society? Or are we inside closed doors debating? That has to be a question. Because this what I find, with all due respect to every judgment I have gone through, my sincerest respect to each of them, exceptions are not being considered anywhere. 20:1, no question about it. It is the final right a man has. Any citizen, any living being has the right to life. It belongs to everybody. We just say that, okay, this sentence, therefore this goes. It be so.
My lord, situations may be different with regard to different facts, my lord. So, my lord, if we constrain ourselves to the facts,
We are trying to concentrate here.
Yes.
We are not speaking out of the context for a moment, sir. A situation where two persons have gone to the airport. A situation where everything is burning outside. A situation where the man is picked up, brought back immediately to Guwahati.
on 8/6, there was peace, my lord. No media report, lordship will find nothing.
Very well.
On 8/6, everything is
With everything done, they bring him back, they produce him before the magistrate. What does the magistrate record? No problems. One judicial officer records. Nothing wrong. We are remanding him. Right? So, are we to say that the judicial officer overlooked everything? We cannot. Then the assertion is that the phone number, where does it come from? Your assertion, I was deprived of every assistance I could have. That means you were alone. From where were the numbers produced? From where did the names come? From the source? Who is the source? Now,
Yes,
someone standing up to say that this is all wrong.
may I make this submission now?
Mm.
Kindly see one thing. It is their report, my lord. They say that first number what I gave was of wives.
Mm.
But one club secretary,
Mm.
one daughter.
Mm.
From
And
my-
someone gave the phone to the sister.
And from my end, whatever I could, I have given.
Yes.
If in such situations, my lord, rather than
They should have let you go. They should have let you go. They should have traced out the entire family tree.
no,
Then they should have come back to
No,
arrest you. Is
not
that
that.
the argument?
my mobile phone was with them.
Hmm.
According to them, they seized 2 mobile phones from me. That is on record, my lord. See
I
that?
can give you my mobile phone, sir. You will not be able to open it. For at least the next 24 hours, you will not be able to open it.
My lord, when suppose an arrest is made in such cases, my lord, a person gives his wife's mobile number,
Hmm.
club secretary's mobile number. Now, club secretary was a major,
Hmm.
and club secretary could also have been furnished. So let me check for that, my lord. First of all, friends, yes, friends is there. They did not make any endeavor to find out what is the age of the daughter. They could have asked him, "What is the age of your daughter?"
It would
Then 48, my lord,
it would not serve any purpose giving it to the club secretary, because knowing that the person is under arrest, knowing that this man has been arrested, knowing that the minor daughter has been given a notice, nothing was done for the last 2-3 months. So he is not a friend.
I did not get. Sorry,
When the club secretary knows, the club secretary was told,
yes,
this man has been arrested,
on the day of arrest.
Yes.
According to them, my lord.
told, no movement. He's not a friend.
No movement means, lordship, he was informed.
The moment he's informed, he's a
Movement
friend.
means I did not. I'm sorry, my lord.
When the club secretary knows about it, his friend knows about it.
Yes. But when call was made by, allegedly made by the CBI,
Ah,
he came to know, suppose.
ah.
Yes.
Then what remains? Then what further remains for the notice?
48, my lord, it has to be in writing. As simple as that, my lord.
That is what I'm saying. This man should have been let go. They should have
Not
made
let
out
go,
that
my-
notice in writing, kept it ready. One man at the club notice, club secretary, other person arresting him, giving him the copy.
Suppose, sir.
That is the only solution.
No, my lord. With all respect, my lord. In such cases, my lord,
Hmm.
if service by WhatsApp is allowed,
No, we are not on the WhatsApp part. We want the service to be made in writing, originals to be submitted
yes.
to a person in Manipur
Yes.
when the arrest is being made in Guwahati within the next 24 hours. Tell us how.
Yes. I am on the point, my lord, that I have provided 3 numbers, my lord. 2 major, 1 minor.
All in Manipur.
All in Manipur. my lord.
Huh.
Now,
WhatsApp
One
not
major-
being allowed.
suppose for a moment, let us say WhatsApp is allowed.
No, let us not have it allowed. Let us come to a solution. WhatsApp is not allowed. How to solve?
If WhatsApp is not allowed, my lord,
Hmm.
then there is a problem, my lord. I understand that. Suppose a person is being held here, no friend, no relative, none. Then it has to be under chapter 6. Chapter 6, my lord, of the, let us see chapter 6. Chapter
6 of
6 of letter BNSS will also do, my lord.
anything. You take up anything.
Or CRPC, my lord, same, my lord, chapter 6 only there.
Which part?
Chapter 6 only, sir. अपने BNSS रहते हैं।
This has to be probed laid down when the situation becomes impossible. What to do?
My lord, can we find an answer here? Let us see, my lord.
Yes.
Chapter 6 to light, na? Yes, sir.
কাইলে কেটা দেখুৱাইছিলিস না 2 minutes হ্যাঁ হ্যাঁ এক মিনিট আগে মানে Yes, madam, it is not these questions are not only to the petitioners. It will also we would also require your assistance on it. It's not as of now. We'll go one by one, otherwise we get confused up.
That he can raise his objection at the magistrate court. He never raised any prejudice.
That will come later on. Those arguments will all come later on, not to worry. But what we want to find out is how were you supposed to serve it in this situation? We are asking him for a solution. Let us see how it can be done. Bodies, procedure and service cannot be affected as before provided.
আচ্ছা আচ্ছা প্যারা 12 to some কি কইছে My lord, I am reading para 12 of one judgment, my lord. My lord, this judgment is approved by the Supreme Court in Satyendra Kumar until, my lord. Para 12, the learned counsel for a respondent submits that efforts were made to intimate the petitioner, including messages through WhatsApp, email, and a visit to the residence of the petitioner of his need to join investigations and to appear before the investigating officer. If the officer visited the petitioner's residence and did not find him there, surely the IO could have pasted the requisite notice under
So
section.
this man goes to paste it in Manipur.
They have their branch, CBI branch at Manipur.
It is during normal.
Then why a person has to go from here and arrest? He could have been arrested and produced there.
It is under normal situation.
In this situation, everything has been transferred, and even the courts in Guwahati, if we are not wrong, were allowed video conferencing for the investigation. Is it the same case? Does it relate to the same case, madam? That video conferencing by investigation by video conferencing, that
Yes.
notification being there, Supreme Court sending everything to Guwahati. It had to be done through Guwahati. These are facts we must know before we touch this case. Now, if you have 69, kindly have 69.
My lord.
When a court desires that a summons issued by it shall be served at any place outside the local jurisdiction. Let us say this is a notice which is being sought to be served outside the jurisdiction of the particular arresting authority. Shall ordinarily send such summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or is to be there served. Meaning, in another case, what the CBI or the customs had done is, they sent it to their head office at the other state. That person was required to have it served as soon as possible. They made the arrangements. They reported within half an hour that, look, this address, no one lives here. It has been under lock and key for the last so and so time. That message was got back. Or we have served, this is a signature, keep it for your records. Some procedure to be done. Is it not? So WhatsApp is what? There are now days where I may be carrying the phone number, you may be carrying my WhatsApp.
Yes, yes.
Is it not? You can have it on a different. In such a situation, WhatsApp may not be the right mode of communication. We agree to it. Here, the situation is totally different. The person has been brought back. Within hours produced. Now, the question of 36 and 48. When people are not within the jurisdiction, argue on that. You have asked us to lay down the law. Assist us to lay down the law.
Yes, my lord.
Or we will also try to find out a way where laid down law will be taken into account and no law will be laid.
Yes, I understand. Now, my lord.
Is it not?
Yes,
So
yeah.
now we have to close it for today. It is 4:35. We'll have to close it for today.
Before I will end up the matter, chapter 6 is for the regular cases for appearance of a person. How to serve the summon. That procedures.
Look before you leave.
This circumstance.
Look before you leave. This is helping you.
Yes, that is.
So
my
don't run away from
On
it.
the
It
last
might help you.
On the last occasions, they were asked to produce the WhatsApp.
So what? No, that they have done.
Give
That
me
they
the
have done.
notes.
That
In
they
the
have
notes.
given us.
Also get a copy, my lord.
Yes, why not
This
give a
is
copy of the?
Given to me, Lord. See,
No, not that part. You have your instructions from the
uh,
officer. All these.
Ask for this thing,
No. What we are saying is,
this one. They have provided me.
if you see this,
Daughter's.
the phone number,
7005155.
515 number. Last number is 15.
that is supposedly the
In violation, my lord. Not before 2 hours. Kindly see the time 3:20.
we agree to everything of it. We agree to the time is
This cannot be
no,
419 and 4.
the specific statement is that the phone number was given in the presence of the magistrate. So therefore, we are talking of handling circumstances where the person presume, even if the court has to presume that the person is not giving the details, is not nominating someone, is not doing anything, then how do we say that even then 36, 48, this manner, not done, gone?
Okay,
That solution has to come.
yes.
Because the situation is what? Do the lawyers are conversant with the law? Criminals are more conversant with it. We know how to apply it. They know how to escape it. Is it not?
I'll go.
If we are shutting doors, if we are trying to shut doors, if we are trying to enforce, then at least to some extent we'll have to make an attempt that it applies to every situation, not only to the situation that we can conceive of. Then it would be a good law which would go up from here,
Yes, yes.
get a ratification, and you can then probably say we had a law laid down.
Yes. I'll try, my lord. Now, Lordship has put all these points, my lord. So, my
These
lord,
are things
will-
which are
I will-
disturbing us from the
Yes.
day we have started looking into 48 and 36 with the intent of adjudicating upon it. So far as we were trying to utilize it, everything was happy. Adjudicating upon it is creating some. But now, if you want this court to continue with the matter, probably not before 19th or something. Otherwise, there is only 1 week in between.
Last day, my lord. Lordship, otherwise.
Tomorrow we are not taking an
Yes,
attempt.
yes. Otherwise, which date, my lord, is available?
It has to be after 19th, provided we are there, if it is to be before us. And if it is, if you now you have all the questions, you can answer any day.
Lordship, I would pray, my lord, 19, my. Because, my lord, I would like to have it on 5th or 6th if possible.
Fifth or sixth, there are a lot of administrative things for which fifth and sixth we are nowhere to be seen.
Early date, my lord, then 19th.
Not before 19th. We cannot give you a date before 19th.
19th, my lord.
19th, it reopens.
My lord, 26, I don't know.
21st. 21st is a Wednesday.
21st, my lord.
22nd is a Thursday. Lesser number of cases. So hearing the 22nd.
22nd.
Questions we have put up.
Yes, my lord.
Answers if forthcoming. Because we cannot have a situation where we just read one sentence and we say that it is all wrong. We are not being able to
No, no,
convince
I-
ourselves
We
to
got
stop
everything,
such.
lord. That questions, my lord, is now,
Answer with.
I am also considering those questions.
It has
Let
to
me
be.
see if that can be answered.
Thank you.
Problem.
পাঠ কৰি 20